All right, let's get started back up. So as promised, I would ask you, before we get into character, questions on the child witness. You guys moved on. Yes?
Would you change your types of questions if the child is much younger, like 4? Like, sometimes they ask questions like, what color is my tie? And he didn't know what a tie was. You know, that kind of stuff.
Yeah, absolutely. I mean, unless you're trying to show that he's not competent, but, you know, because I think especially at young ages like that, there's a vast difference between some kids are super verbal when they're 2, and some kids aren't even that verbal when they're 4, you know, so there is going to be a difference in the witness. So I think, yeah, certain things they don't know what a tie is, but if they don't actually know their colors, you know, I mean, there's going to be a big difference. So, yeah, it's, yes?
Do you have any recommendations if sort of how a lot of the judges do not want children to testify, and now there's some case law that indicates that judges can make that call and say, no, we're not allowing you to cross-examine the child.
Right, so obviously you're going to do process issues, but I think if you lay your record, and here's the thing, you have to know what's in the record, right? And you have to have a reason for calling your kid, just like I said. There has to be, are you, so I put it in here, and this is what we're addressing. It's in here, it was not on my slides, but you'll see it. Where the heck is it? It's, should you call the minor? And the reasons why you would call the child, oh, here we go. The reasons why you'd call the kid, you know, get a recantation of a prior statement, bring out inconsistencies in the statements, add to the minor's story, add emotion to the story. And I said, notice that fishing for unknown facts that may help your case is not on this list. You should almost never call a witness for this purpose, especially a child witness. Child witnesses are afforded more protection than adult witnesses. See, for example, 765B. And the judge will be careful to put a stop to examinations that tend to harass or embarrass the child with no obvious purpose. However, if you make a record, you know, state, tell the judge, I have an offer of proof, you know, this is what I'm trying to get out of the child. It's not addressed in the social worker's report, you know, this one-sided, didn't put it in there. So this is the stuff I need to get. If the social worker had done her job, I wouldn't have to ask the kid these questions today. Right? So if you make an offer of proof and put on the record why, I mean, that is meant to stop you from putting the child on the stand to go fishing. If you have a real reason to put the child up, then that should never happen.
I've had, because my judge doesn't really like me to call child witnesses, you know, but I think out of 2-6, what I try to use as an offer of proof of why you need to put them on is that most of the reports say that the kids are happy and well taken care of and they like where they're at. But it doesn't tell you whether that kid knows what adoption means.
Right.
And so I want to know if this little kid knows what it means, and do they know that they're never, ever, ever going to see their real mommy again, right? Because sometimes you do get that emotion from a kid that is happy to you, except for when you don't.
Yeah, I imagine I could backfire. But, yeah, no, I think, look, the judges, I mean, essentially, it's a lazy, that judge wants his or her job to be very easy that day. They don't want to make hard decisions. It's lazy, you know. That information is valuable to your case. And so I would fight for it. You know, if your judge is intent on, your judge is still the judge. So you may lose, but I would still fight for that. You know, I mean, you're not going to be in front of that judge for the rest of your career. And, you know, eventually, one of those, the nice thing about dependency is we freaking appeal everything, right?
Yes.
Like, appellate defenders, you know, we got to keep them in business. So, you know, eventually there's going to be one where the appellate court goes, oh, this is bullshit, right? So just keep doing it. I would keep fighting for it. There was another hand going up. Oh, Rachel.
Is there any strategy in terms of having minors counsel qualify the child versus us qualifying the child? Because in LA County, I've only ever had minors counsel qualify. Even if I'm calling the witness, minors counsel will start by qualifying them.
I don't know if it's a local rule. I mean, it's not a requirement. I don't know that I would care one way or another. The only downside is that it takes away your ability to build rapport. So I would ask the judge for some leeway in the beginning of my exam, that I'm not going to jump right into the day of the molest. You know, I'd like to talk to the kid and ask her some questions that you know, build a rapport first too. So that's the only downside that I would see to that happening. That sounds like it's just sort of the practice. Maybe there's a local rule, but I don't think it's bad as long as you can still rapport build with the kid a little bit. You know, I mean, you just don't want to jump into the dirty stuff on your first couple questions. You want to get them loosened up a little. That's bad. She's looking at me like So, does anybody have a horrible, like horror story of a child on the stand that went horribly wrong? Yeah. Oh, jump.
Yeah, this was good. The dad said that if I called him to testify, he would definitely say that his dad never beat him. So I called him, and then somehow the kid ended up testifying that his dad uses a belt. Oh, and his dad's wearing the belt today. And
he had like that big belt buckle on there.
And so then the dad was really mad at me afterwards. He said, "You telling me I can't beat my kid?" I'm like, "No."
You told me you didn't.
Yeah, I mean, you know, there are definitely a bunch of times where I've told my client, I'm not calling the kid. Sorry. Like, the kid was interviewed 3 times, the statement is like, they're exactly the same. Like, the kid knows this story, whether the kid's been coached, I don't know, but the kid tells the story exactly the same 3 times to 3 different people, and it's bad for us. Like, I'm not going to call the kid in that circumstance, probably. I watch the forensic, and I'm looking for something that's different, right? You're looking for inconsistencies. You're looking for a kid who's not too sure. But you can kind of, it's one of those things, it's like pornography. You kind of know when you see it. You're like, this kid's going to be bad for us. You know? So there are definitely times where you tell your clients, I'm not calling the kid. And then, oh, you have to. I'm fine. Okay, buddy. I wish you could fire me, believe me. But I think I'm still on your case and I'm still not calling the kid. You know? But then there's times, if they're going to put the kid up anyway, you should cross. I mean, then you didn't put him up. It's not my call, Judge. I'm just, you know, what am I supposed to not ask questions? But really, it should be a red flag if they're putting the child up, because what did they not put in the report? You know, are we getting something new? I don't know. So, that's enough on the brat witness. Now let's get into the complicated stuff that everybody gets wrong. The precursor to this is your judges should be here for this because they screw this up all the time. All right, character evidence. If this were a criminal training, I'd go character evidence. It's not allowed. You guys can go home now. Super easy, right? But we're in dependency court, so it's way more complicated for us. So we'll start off with evidence code 1101. 1101 says evidence of a person's character or a trait of their character, whether in the form of an opinion, evidence of reputation, or evidence of specific instances of his or her conduct, is inadmissible when offered to prove his or her conduct on a specified occasion. Okay, question?
So, at what point, like, procedurally do you object to this, like, before it's admitted or attempted to be admitted into evidence, right?
Let's define it first, because I think this is where people get screwed up. Is what does this mean? What are we talking about? So let me define it before we ask that question. If I don't answer it, don't let me off the hook. So the general rule is it's inadmissible. This is the general rule. Okay. There are exceptions. Dependency is one of them. Okay. When character or trait of character is an ultimate fact in dispute. How can it be inadmissible if that's what we're fighting over? Okay, so if you think about it, this is a lot of dependency cases. The best example is a 300J petition. That's a character petition. You're saying, so here, let's read we'll quote it first, and then the court shall consider the circumstances surrounding the abuse or neglect of the sibling, the nature of the abuse or neglect of the sibling, the mental condition of the parent, and any other factors in the whole freaking world that the court considers probative in determining whether there's a substantial risk to the child. So, you know, this statute is a character evidence statute. Okay? Character evidence, what's your name?
Sean?
Sean clearly is an abusive guy. Okay? That's character evidence. Sean, what's your name?
Jason.
Sean punched Jason during the break. I watched it. Okay, so I'm pretty sure Sean's going to punch me because I saw how violent he was. That's character evidence. Okay? If I go outside and get punched in the face mysteriously, and you guys go, obviously it was Sean because we know what a violent dude he is, that's character evidence. We know he punched Jason in the face, so he probably punched Kevin too. That's a J petition. Okay? It's a character petition. He's a violent dude. He did it before. We're afraid he's going to do it again. Okay? Character evidence is complicated. I gave this training for the AOC once, if you remember what the AOC even is. The Administrative Office of the Court, they don't exist anymore. But I did it as a webinar, and people were typing like, WTF, and like, it's a weird subject, so please don't be afraid to raise your hand and ask questions. So, another example besides a J petition is the substantial risk clause in 300s A through D. Okay? In asking the court to make an assessment of whether the child is at substantial risk of abuse or neglect, instead of proving that some certain abuse occurred on some certain date, aren't we putting the character of the parent at issue? Okay? If the court is determining the occurrence of a certain act on a certain date, that's not a character inquiry. So let's go back to Jason and Sean. If we're trying to prove that Jason punched me in the face out in the hallway during the break, we're not litigating his character. We're litigating whether or not he punched me in the face. Okay? If that's it's an assault case. We want to know, did he punch Kevin in the face? Is he going to, be charged with a crime? That's a specific act on a specific date, on a specific time. Did he do it? That's not character. But if you frame it like a J petition, where the law says you're allowed to assume he's going to punch me in the face if he punched Sean in the face, do you guys understand the difference? So one is the law determines that you know what happened on this date at this time. The other is saying he did it before, so we think he's likely to do it again. This one's character. This one is a specific instance, and they're different. So 300J asks for, if he did it before, he's likely to do it again analysis. So does this clause in all of 300 A, B, C, and D. Okay, so there's two ways you could plead an A, and I don't know in your county if they distinguish. Okay, do you guys distinguish between the substantial risk clause versus it happened? I assume in your petition it's going to say, Dad beat that guy's client with a belt on June 1st, of 2018. Okay, that's an A petition. But if it's pled that he's at substantial risk for physical abuse because Dad did some other thing, that's character evidence. Okay? There's a difference. So here it is. The child suffered. Okay, so this is the first thing. We know he hit him on June 1st. Case closed. That's the first part. The child suffered, or there's a substantial risk that the child will suffer. Serious physical harm inflicted non-accidentally. Court may find there's a substantial risk of serious future injury based on the manner in which a less serious injury was inflicted, a history, this is that's a typo, a history of repeated inflictions of injuries, or a combination of these and other actions by the parent or guardian which indicate the child's at risk of serious physical harm. So when that's being pled, it's a character inquiry. Okay? This, he hit Jimmy on June 1st. This is, he's a bad guy who hits people. We're afraid he's going to hit Jimmy too. They're different. Right? Do you guys, when they're pled, are they pled differently? Do you know?
They're pled.
They just write the whole statute?
Yeah, they write the whole statute.
So, but you read the report and you say, okay, they're alleging he hit little Jimmy on 3 different occasions, right? So, all they have to prove is that he did it, right? And then it's over. It's a little more in depth to prove the substantial risk. If we don't know that he actually, if he never really hit Jimmy before, but, like, have you guys ever had a DV petition pled as an A?
Yeah.
That's it, right? He beats the crap out of mom, so we're afraid he's going to beat the crap out of little Jimmy someday. That's the substantial risk clause, right? He's never hit little Jimmy.
They usually get kept in my court if little Jimmy got hit trying to take dad off of mom.
Oh,
That
yeah,
isn't
well
it.
then little Jimmy got hit.
Right.
But I'm saying, I mean, really, if he's never hit little Jimmy, shouldn't that be a B?
Yeah, we usually get to strike those.
Okay, but it,
Sure.
it's properly pled as an A because of the substantial risk clause. Question?
What we'll have is like,
I can't hear you.
what we'll have is if there's like 3 kids, maybe just hit Johnny, but Melinda and Frankie are at risk too, but it's an A, B, and J.
Right. And a J, I mean a J's out, a J is a character petition. But this can be too. The best example is a DV petition where no kid's ever been hurt, harmed, or anything, but they plead it as an A that little Jimmy is at serious risk of physical injury. Right? So that's how you know. We're in character land. We can put character evidence in at jurisdiction. Okay? If they're proving that he hit little Jimmy on June 1st, nope. No character evidence is admissible. Okay? This is, it's kind of a hard distinction. So the case, but I'm really smart for coming up with that DV example. So look, Cheryl H. Let me start down here. A Psych Eval is the ultimate character evidence. Have you ever gotten a Psych Eval on a D petition? Anybody?
Yes.
Like you pay for it, you get your own?
Yes.
That case where we got the D dismissed with the 17-year-old on the stand, I sent that guy for 2 psychosexual evaluations. They both came back. He loves little kids. And he flunked the polygraph too. So, she's making faces at me, the former minors council. So look, this is the ultimate character evidence. You're doing psychological tests to find out if he's a pedophile, right? They do that. Do you guys know, maybe you can advise your clients, I can't remember the name of the test, in a psycho, so you have your standard Psych Eval, the MMPI-2 and all those, tests, and then, but if you do a psychosexual, they have this test where the guy I'm not being said, it's always a guy, let's be honest. The guy's sitting at a computer and they show him pictures of kids. Oh, well, and adults. And he has to rate the hotness of the person on the screen 1 through 10. So they'll show like Christy Brinkley, right? And then they'll show like a dude, like a construction worker. And then they'll show little Jimmy on the slide. And so he has to hit, and if he's smart, he goes, well, that's little Jimmy, that's a 1. Right? There's Christy Brinkley, she's a 10. The computer program does not actually keep track of what they rated each picture as. it keeps track of the amount of time it takes him to answer. So if he has to think about it for a second with little Jimmy, oh, Jimmy's hot, but I need to push 1. There's like that half a second delay. And so they're keeping track of it. It's crazy. So that's character evidence. They're saying he's a diddler, right? Science tells us he likes little kids. So that's character evidence. He hasn't diddled anybody, but we have a test that shows, at least a probability that he's sexually attracted to minors, okay? Or vice versa, it might say he's normal. In Cheryl H, they didn't do that test. This test is relatively new. There's 1984, they didn't have a computer. They had like what would have been around an Apple IIe. In this case, it was the MMPI, and it was, the guy was diagnosed as being like super defensive, and he had all these other traits that came through in the MMPI, and there was a study that they correlated it, and something like 90% of pedophiles shared all those same traits. That's what his psych said. So anyways, Cheryl H says you cannot use a psych eval to prove up molest on a specific occasion, right? And this makes sense if you just think back a slide. Character evidence is inadmissible to prove a specific act on a specific date. Okay, so he's accused of actually molesting little Cheryl on a certain date. You can't use it to prove that that happened. Okay? If it were a J petition, it'd be different. So, the court held that Evidence Code 1101 prohibited a psychiatrist from testifying based on standardized psychological tests that the father had a character trait or a propensity to sexually abuse children. They could not use that testimony in order to establish that the father had in fact molested little Cheryl on a particular occasion. Now this was back in the day when the court ordered a psych eval. Hopefully that doesn't happen. Did the court order a psych eval pre-dispo, pre-juris here?
Not
It can.
Right.
Right.
I used to have a judge that would suggest it. Counsel, I can't order it, but I suggest a blanket of psych eval. I suggest I don't tell you anything about it if it does. So the court held no. It's an A, and the allegation is that the child had suffered an actual molest. So you cannot use this piece of character evidence that says dad's super creepy to prove that he actually molested this little girl on a certain date at a certain time. Okay? So they said, nope, it's out. And the trial judge in this case had let it in. They made a true finding. The court sent it back and said, no, you can't consider that psych eval. But this works in our favor later. So it doesn't matter that this particular instance doesn't happen anymore. You know, the pre-jurisdiction psych eval. So that's Cheryl. Dorothy, right after Cheryl's, they're both 1984 cases, but Cheryl came first. It says character evidence is okay if it's not being used to prove up a specific act. Okay? It acknowledges, this is the first case that acknowledged that character evidence, character itself, is at issue in dependency cases. Alright, so I'm just going to read this because it's a quote. Evidence Code Section 1100, it's really 1101 I think, does permit evidence in the form of an opinion, evidence of reputation, and evidence of specific instances of such person's conduct when the parent's character is the central issue. Established laws recognize that the character of a parent is at issue in child custody actions. Okay? The same concept applies in dependency. So, the family courts had long allowed character evidence to be put in. So, if it's a custody battle, one parent's allowed to say the other one, you know, he's a bad guy. Because it's a comparison between me and you. It's a best interest standard. Okay? He's a bad guy. I'm nice. I should get more custody than him. That's allowed in family court. So they're saying, look, this is kind of the same thing. We're talking about the best interest of a kid. And this, in Dorothy, It was not a specific act. In distinguishing the Cheryl H. case, Dorothy I. Court explained, in our present case, the character evidence is not being used to prove a charge of past conduct against appellant. It is being used in helping the court determine his predisposition toward future sexual abuse with the minor Dorothy. This type of character evidence is essential. Oh, I wish my little laser pointer thing doesn't work on the screen, but it's essential when available to aid the court in dependency actions which are concerned for the future well-being of a minor. So in order to understand this, let me tell you the facts of Dorothy I. I forget the guy's name, let's call him Frank, the dad. Frank had a baby. Frank molested his baby. It was bad. Frank went to prison for like 10 years. Frank got out, and as somehow miraculously child molesters do, he found another lucky lady to shack up with. How does that happen, by the way? You're like, yeah, I did some time for molesting a kid. Oh, it's all behind you. I don't know. He found a new lady, got married, and he had a new kid. And the agency, Cloak and Dagger folks, came in and went, look, Frank's a child molester. You're not bringing this baby home to Frank. Frank never molested little Dorothy. Hell, he never even lived with little Dorothy. They pulled, I think, if I remember, they pulled Dorothy early. But Frank never molested little Dorothy. Frank molested the other kid 10 years ago. And so this was not a specific occasion petition. This was a substantial risk petition. Okay? They're saying little Dorothy is at substantial risk because old Frank here has a propensity to molest kids. And old Frank says, no, I was just drunk one night. It's not a real propensity. So the Psych Eval in this case was done by Frank and Frank's lawyer. Frank's lawyer sent him for a Psych Eval. Okay, and it came back that said Frank's pretty normal. And Frank's lawyer wanted to put that into evidence at jurisdiction. Okay, not dispo, at juris, to disprove the petition that there is a substantial risk of Dorothy being molested. And the court originally said, no, we just learned in Cheryl H. that you can't put a Psych Eval in a jurisdiction. And the appellate court said, you guys are dumb. This is not a specific instance of molest. We're talking about character here. We're talking about, and it's character. So a lot of times you'll hear, especially in criminal circles, character evidence is called propensity evidence. Okay? So we're trying to prove that Frank has a propensity to molest kids. We're not trying to prove that he did it. Right? This is like, what's that movie? Minority Report. Tom Cruise. Where he's going to do it. We don't want to give him the chance. That's character. So, since they are attacking Frank's character, Frank's lawyer has the right to put into evidence at jurisdiction Psych Eval that says he lacks a propensity to molest children. Questions? There's got to be. Yeah.
So, a lot of moms obviously have a new baby post-adjudication, post-juris. So, every time the department snatches up a new baby based off of the old petition, we think of the propensity evidence.
It's a substantial risk petition at that point. Even if they file it at, let's say, so they can file, let's say it's a physical abuse case, they can file the new baby as a J or an A. What, in your experience, do they usually file it as? Or both.
They just copy and paste the whole petition.
They're like, here's all of WIC 300.
Alive at that time.
Yeah.
I have done it in the past, and I've done one more recently, but in the past I did a guy, I didn't do a guy.
Training's going
I had an
down.
evaluation done privately, I figured, because I really didn't think of the way the fact situation was, and I got it, and in those I had sent to the social worker like I would send a report or something like that. She included it in the PRC report, juris report, came to court, everybody read, just dismissed the case. I will send it out sometimes because you don't send it on every case, but nobody knows unless you're going to introduce it. And I did one more recently too, when it came out. The guy was a school teacher, and it was a fabulous. And I held on to it for a while because it was an issue of certain things that were going, but it was a great report. They ended up dismissing the petition, you know, just prior to the time when I was going to turn it in because of the things they were along the same line. But it's something that I think we should use depending on the case. If it's bad, obviously you're not going to share it with anybody.
Right.
But if it's good, it can be really good ammunition to try to go against, and if you have to bring, you know, the doctor in at the time. But it's
absolutely.
very good.
But that's a Dorothy I type case. So if you're the supervisor, I don't know how it works with money at Ladle, but like at my old firm in San Diego at DLG, I would approve the expert. I was in charge of the budget for my law firm. So I would approve a psych eval pre-juris for someone in this position. But if they're actually accused of molesting their kid, like if the kid said, "Daddy came in and touched me," no, it's a waste of money. Like, don't get a psych eval, it's not coming in. If your judge understands character evidence. The problem is most of them don't. So the first time you do this, I'm going to come to you. The first time you do this, you may want to file, you may end up fighting about it in writing. Yeah.
So, I hadn't really considered this, and I want to know maybe your thoughts on like how beneficial it is. But like in the DV case that you alleged earlier, give us some example of, like, so we could bring in character evidence that like this guy volunteers for kids and is not. No, you can't.
No, I'll get into that. So when we're talking about, and this is where it's helpful to call character evidence propensity evidence, because you have to be specific. And there's more slides. I will address this directly. But this is the propensity for the thing. So if this is a molest case, it's propensity to molest kids, right? When we get into 300 and the substantial risk clause, it's specific. Right? So the kid's at substantial risk of what? Of serious physical abuse, of sexual abuse, whatever. It's specific, so your evidence needs to be specific. I'll get into that. I call that the church letter. I'll get into the church letter in a minute. Yes?
So when you say that character evidence like this eval can't be used to prove a specific act, as it follows from what I understand you're saying, it also can't be used to disprove a specific act. If, like, you have a family law battle, mom thinks the kids are molested, dad brings in, and there's a specific incident that on this date, allegedly, he diddled.
Now,
they can't bring in an evaluation to then say, well, it's not true, I have no propensity, I have no...
Correct. You cannot use it to disprove.
So then, how specifically is the objection made, and this is, again, this is an admissibility issue, not a weight issue, right? It shouldn't even come in.
This is admissibility, not weight. Now, it should be really, I'm teaching you this to get you to do it pre-juris on substantial risk type of cases. The reality is, the other side, unless it's like a new baby, the other side should never have a psych eval of your client unless, pre-jury. I mean, it just shouldn't. The Cheryl H. circumstance should never happen again, right? Where the agency has a psych eval. Am I understanding your...
Yeah, sometimes you're pitted against the other parent. And,
and you're saying they got a psych eval from the family court case?
Or retained their own private individual, like it's a case of, they're saying, I guess I'm just thinking of the typical, there's a lot of family law sex abuse cases where they say it's a family law case.
That's how you win.
Comes in dependency court, and because of allegations of molest by dad, and dad says, Mom, this is a custody grab. Mom is saying no, and I've had a circumstance where then the dad's counsel retains a 730 a private evaluation with propensity.
Yeah,
it shouldn't the AAPI or whatever.
It shouldn't come in unless it's a substantial risk. So if, in other words, there's a difference here. So I'm just trying to think of the typical kind of custody one.
I guess the problem I have when you, sorry to
Go ahead.
interrupt, but when you say that there's a distinction between specific acts and substantial risk, our petitions are usually pled
Together.
that on or about this date, father touched the child inappropriately or whatever, and such conduct places the child at risk, substantial
For
risk of
future.
harm.
Right.
Right.
So
they're
the
pled
law
both
says,
as-
in California, the law says if you did it, there's a whole bunch of case law that says if you molested this kid on this day, the kid is at risk for molest tomorrow.
Right.
Right? So that's a specific act petition.
Right.
Can I ask a question? What
If there is, there's a bunch of case law that says if dad molested little Jimmy in February, there is a substantial risk that he's going to molest little Jimmy in August as well. So it's still a specific act petition. The thing is, if you have a date, character evidence probably shouldn't come in. So that usually comes from the child. If the child says, when daddy puts me to bed on Saturdays, because he goes out drinking or, you know, whatever. If there's a date and there's a specific, even if it's a kid, the kid's not going to say on the 28th. But if there's a specific instance of molest, you're not in character evidence territory. It's the best, the reason why I bring this up is it's the most obvious example of a non-specific occasion, because he never even like lived with this kid. They're just saying, you're a child molester. That's attacking his character. They're saying, you're a child molester, right? So let me get to you because I got a couple more.
Okay.
What about, I'm sorry. Sometimes we have a specific incident that is unclear whether it's sexual abuse or not. It's not like a specific sexual act, and it's not, you know, there could be an inference that it meets that penal code definition 1165. So what
But
about
is this the like changing the diaper and something weird
things
happened?
along those lines?
Okay.
Yeah. So what about for showing that did fall under the normal caretaker thing as opposed to for sexual gratification?
Yeah, I think you got to write a motion. I mean, if you're going to argue, look, if the specific act is fuzzy, maybe you can write a motion in limine and say, let's say you send him to get a Psych Eval and it's fantastic. You might want to file a motion, and I give you more cases in here than what's on my slide. You may want to write a motion and say this is really a substantial risk petition because of all the holes in the specific instance. Maybe, you know, you can argue it both ways, but my feeling is if there's a date or the child's testimony of what daddy did to me, that's a specific instance, right? Even if it happened 10 times, it's just 10 specific instances. Yes?
Sorry. So then I think a good example of a usage of character evidence would be in a petition where the allegation is father's a registered sex offender, that places the
Yep.
child at risk of harm,
Yep.
and we have the burden of
Absolutely.
producing.
Yep.
Okay.
Absolutely. You had your hand up before.
No, I'm good.
Okay. So that's an excellent, I'll get to you. That's a good example. That's just like this one. Yeah, it's going to be where there's, you know, that the guy is not accused of molesting this kid, or mom is not accused of actually hitting this kid. Okay? Yes.
So you can get in a kind of evaluation if you got 2 counts. Because I had one once where it was dad had done something when he was 14 years old that was inappropriate to a child. Right? And they pled that, and then the other allegation was he had a 2-year-old, and they did say that he had sexually abused her based on the little girl saying, you know, it's red right here. And then mommy asked, how did that happen? And she said, it's red because of dad. That's what mom said, she said.
Right.
So I think that I did try to get in evidence. We didn't have the exact evaluation, but there was I put on his therapist in one of those kind of sex.
See, but now, this case law is only talking about a jurisdiction. Okay, when you move past jurisdiction, so this is trying to get the petition dismissed, saying this is bullshit, this kid's not even at risk. Okay, when you get into dispo and review hearings,
Well, this was actually pre-adjudication
Okay,
because
okay.
these sex
But you already
abuse
had a
get
therapist and
continued
everything?
so long sometimes that you
Okay.
have this guy going to therapy for a while and then you get
okay.
out, you know. that
Yeah, well,
kind of
same thing, therapy is going to be the same thing. You know, there's a different twist. I mean, therapy isn't as direct as a Psych Eval as far as character. But, and I
Well,
want
they
you to
did
think,
those kind of evaluations there because it was
Yeah,
that type of
that's-
therapy,
yeah.
you know.
and I don't want you to think that's the only type of character evidence, right? Character evidence is just evidence of him being a child molester. So if they want to bring in other things that he's done that are a little bit shady, I don't know what an example would be, but, you know, his pants tend to fall down whenever he walks through the metal detector at court or something, I don't know.
How about criminal history?
Same thing. So I'll get into that because that comes in the report, right?
Okay.
One more case. This is the same as Dorothy I, kind of. This is in Remark C. Very embarrassed that this case came out of San Diego. It supports the conclusions of Dorothy I, which says that look, if it's not a specific act, we can offer up character evidence. Except father's counsel, it wasn't me, did not offer proof of what the Psych Eval would tend to prove in opposing county counsel's motion in limine. So they're saying dad's lawyer's an idiot, but we reaffirm everything in Dorothy I. By enacting Section 300 Subdivision J as an alternative basis for jurisdiction over a dependent child, the legislature apparently intended to place the parent's character at issue. Right? So J petition is the most obvious example of this. So those times when they pleaded as an A and a J, you could bring in your Psych Eval if it's good. So you could say it's a J. I mean, these cases are directly on point for J petitions. All right. Well, this is just to confuse you. This is habit evidence. Habit evidence is different from character evidence. Character evidence is general, like you're a violent dude. Okay? Habit evidence is I eat my Cheerios every morning at 8 a.m. Okay? That's different. It's not part of my character. Okay, I'm not a you would never say you're an 8 a.m. Cheerio eater. Right? That's like a character thing. No, that's just my habit. I eat Cheerios at 8 a.m. Okay, so habit's different. Habit evidence comes in. So I tried to think of a way that would come in a dependency case. I'll get to it. It's a bad example. You guys maybe give me a better one. Any otherwise admissible evidence of habit or custom is admissible to prove conduct on a specific occasion. So I couldn't think of anything. Here's what I said. Mom's position at juris is that she did not neglect the kids. Every day for 2 months, the motel housekeeper walked by Mom's room and saw Mom feeding the kids cereal for breakfast at 8 a.m. The housekeeper is allowed to testify that Mom's daily habit of feeding kids Cheerios at 8 a.m. You're allowed to bring her in and say, every day she feeds. Now, even though this lady didn't literally see her every day, but every time she happened to walk by at 8 a.m., there's Mom feeding them Cheerios. That's her habit. She can come in and say she gives them breakfast every morning at 8 a.m. Okay? But she can't come in and testify to Mom's general character for being a nurturing, responsible mother. She can't go that far. She could just talk about breakfast. That's habit. It's not character. So she can say Mom is a cereal feeder to the kids. That's it. Right? So just wanted to confuse you a little bit. Did your hand go up or you stretch it? Questions about habit? I'm trying to think of a better habit example, but I don't know. I'm trying to think of it in a drug context. You know, she always puts the needle back. I don't know. But habit's different. Habit comes in, generally, and character is excluded generally, except for in our couple exceptions. So, when do you want to present character evidence? The best is similar to Dorothy. Your client abused little Jimmy 10 years ago. Now he has little Tommy, and even though there's no current accusation of abuse to little Tommy, the department files due to risk of sexual abuse. That is a character case. All right, so questions. What other kind of cases do you foresee this happening in? What about a drug case? What about a B petition? And I'm not asking because I know the answer. I'm asking your opinion. A B petition where mom's a habitual meth user.
Talk about for character or habit?
Character.
I think
You know, the
get
petition
into
says,
that.
mom is, I don't know, how. Give me the wording. How do they word like a meth petition? What would it say?
It says on this date, mother tested positive for methamphetamine, and on prior occasions, she was caring for the children while under the
What about without a test? I mean, you get them without it.
It also says mom is a current user and has a history of substance abuse, including but not limited to.
And then on this date, mother was arrested for.
Right, but let's take out the specific facts. I want
Because
to.
it still prevents because if she was just arrested for this, like,
Okay.
3 months ago.
I mean, what do you guys say? I want to kind of figure out because I haven't thought through a B petition, a drug petition.
I had a case just earlier today where they were pleading that mother was a user of marijuana because she was arrested for possession, but then she tested for, drug tested her and all of her tests came back clean, which for marijuana stays in your system for a really long time. So they were using her conviction of this so many years ago
Yeah,
to say that she was a user of marijuana.
it's pretty bad. She got caught carrying a legal plant.
It wasn't legal when she got caught.
I know, but now it is.
It's
So
a bad position.
I don't know. I mean, I think if it's not, you know, a pause talks baby or something like that, where they just say mom's a habitual and current user of methamphetamine, that sounds like character. What do you think? You
I
have
think really the only time we see that is when mom's substance abuse history is being backed onto a petition having to do with something else.
So what about new baby? Mom's lost a couple of kids
Exactly.
due to drug use.
It's gonna be a case where there's something else going on, like there's a domestic violence allegation as well, and we're gonna slap on the fact that mom has a substantial history and her previous child is in a permanent plan of legal guardianship
Right.
because of her history. It's gonna be something that's piggybacked onto something else.
But if it was a new baby, regardless of what the first case could have been all of that. It could have been DV, it could have been drugs, or let's say it was just drugs. It was a pause talks baby, and she lost that kid. So now you have a new baby.
She didn't get him back,
Right.
then it'll say that mother has a history of substance abuse, and additionally, she lost her children were, you know, in a permanent plan, whatever.
No family reunification.
Right. It's a
So
no
that
FR
sounds
right.
like character, don't you think?
That's good.
That's good enough.
I mean, it's just with drug, the difference with saying someone's a child molester versus someone is a drug addict is the tests are a little more concrete with drugs, right? You can actually send them for drug tests. And if they come back clean, you can, with a straight face, say she's not a drug addict. You know, it's a little more subjective
What
when
about
you're.
the allegations that say father is a controlled substance offender, he's a registered controlled substance offender?
Yeah, the
And there's
repeat.
no specific allegation other than the fact that he's a registered controlled substance offender.
Yeah, I mean, that screams character evidence, you know? And if you could send him for a Psych Eval that says he lacks dependent tendencies or whatever, let's say he's in recovery and he's kicking ass, then I would absolutely send him for an eval. And then you could bring in people to talk about if he's using drugs and stuff like that. But the difference, so, when characters, all right, this gets to it a little bit. When character's not at issue, an example is when the agency is proving a specific act on a specific date, which includes a series of events like drug use or ongoing domestic violence, But of course, once you have a positive test, or you have someone gets arrested for DV, that's specific acts, right? We know, we're not saying that they're at risk at DV. Let me back up. If the petition says there's a risk of DV because this guy beat the crap out of his last girlfriend, that's character. If someone got arrested for DV, we have a specific instance, okay? And same thing with drugs. If they're just saying she has a history, that sounds like character. But if she has a positive drug test, or it's a pos-tox baby, or whatever, you now have a specific instance. And you could have a series of them. They could say she smokes, you know, meth every day. She has a $10 a day habit or whatever. In those cases, you should not be presenting positive character evidence of the parent. You should also be objecting to character evidence in the social worker's report. What's an example of that? I'll tell you what drives me freaking crazy. Prior referrals. What the hell do they prove?
Unfounded prior referral.
Yeah, unfounded prior referral. I mean, that's character evidence. You should be objecting to that. Now, realistically, is the judge going to tear that page out of the report? Probably not. But you should maybe make a stink. What time is it? You guys, I'm going to try to figure out something so we can knock it done early. I know you guys want to stay. It's Friday. It's super comfortable in this room. All right. So the case law is fuzzy here. That's the bottom line. This shit is complicated. I guarantee you your judge does not know the difference between specific instance petitions and substantial risk petitions. I guarantee you. All right? So the first time that you want to put a psych eval in at jurisdiction, I would suggest writing a real short motion. Everything's in here, you know, just shepherdize it real quick. I did it last week and it's all still good, as far as I know. Don't put my name on your motion though. It's kind of done for you. So say I get to show you this, judge, you know. Your judge will likely not want to hear general character evidence. This is the stuff we're talking about, okay? Because remember, the statute says that this is inadmissible, except for certain instances. So generally, it's inadmissible, okay? I call this, you guys get the letter? I got a letter from my pastor.
Yep.
I'm like, awesome, let's see it. What's it say? Dad's a really good guy, he comes every Sunday. He volunteered to help build the playground. You know, yeah, he umpires Little League. That stuff, I mean, to a person who's getting their kid taken away, that stuff's relevant, right? But it's general character evidence and it is inadmissible. That's the dad's a good guy letter. The dad's a good guy does not disprove that dad diddled little Timmy. You know, it's not the same.
Right.
So, leave that stuff out. Does anybody's judge take that stuff?
They do, and sometimes our clients give them to the dependency investigator. So again, they're just
What the heck's a
attached.
dependency investigator?
The social worker who's writing the report, the jurisdiction report, and
The
so
independent one.
then they'll staple right.
Sure they are.
So then they'll staple it to the report, and it makes the clients feel better.
Okay, so if they take them, great. Yeah, it makes your client smile. But should you be like, hey man, get me a letter? No. And if I'm your judge, I'm going to tear that part off and say this doesn't matter. You know, it's just not relevant. So you have to think of what character trait are you proving or disproving. Okay, so if it is a character case and you're proving their propensity to molest kids, it's probably relevant. If you're proving that they go to church every Sunday and he's really nice to the people that he sits next to, who gives a shit, right? So leave that stuff out. I say, don't let that agency/department get away with the negative equivalent of the church letter in their reports. So, unfounded prior referrals. What else comes in the reports where you're just like, this is just here to badmouth my client. Has no relevance at all.
Well, a letter from the niece that he hasn't talked to in 6 years is saying he is a horrible person and I don't speak to him anymore.
Right.
Ex-wife.
Right.
Yeah.
Family members of the other parent.
Interview from the neighbor.
Yeah.
You know, he kicked
I mean,
my
if it
dog and whatever.
Yeah, if it talks about him, you know, whether or not he's a good guy, if it gives an inference that your guy's a bad guy or mom's a bad gal or whatever, it's probably negative character evidence. When that light goes off in your head, you go, what the hell does this have to do with anything?
Yeah.
It's probably character evidence. They're attacking his character.
I would say that anytime I hear them say something about, oh, this person's a gang member.
Yeah, the problem with gang member, I mean, when you get into the criminal statutes, there is a defined, that means something specific under the penal code.
Right, but under our purposes, like, okay, what does that mean for the kid?
Oh, I agree. But it's, at least there's a basis in law for that. It's not like, but yeah, I think that's, I think that is character evidence. I think their priors are character evidence. You know? So, here's the problem that I'm pointing out to you, is that the department puts a lot of this shit in. It's kind of rampant, and it's not supposed to be there. So, start objecting to this stuff, you know? Especially if you feel like it matters. Like, you know, you have a case that's kind of borderline. You got one of those ones you feel like you might win. Come around once in a while. Start objecting to this stuff. It's bullshit. It's not supposed to be in there. And when you have character at issue, a jurisdiction, don't neglect it. Right? Put your evidence in. What else? There were other hands that I ignored. Yes?
In a physical abuse case, if you've got family member, neighbor, whatever, babysitter who does not claim to have been present for the, on the day in question that this physical abuse supposedly occurred, but has seen the parent and child interact regularly and has seen how the parent disciplines the child, is there any argument that should be admissible, maybe as habit evidence, or?
Well, is there a specific instance that
There's a specific instance of abuse alleged.
So remember,
in the petition.
I don't remember the case law, but if, and I'm not talking about discipline, but if mommy physically abuses the kid, you lose on jurisdiction.
Right.
Right? If she did it once, if she beat little Sally with a belt, you lost the A. Your fight is dispo. Right? Your fight's not juris there. Because as long as that specific act is proven, the law says that that's enough to take jurisdiction. So, if I had my little 300 up again, it only has to happen once for us to lose, right? It doesn't have to be ongoing when it comes to A petitions, okay? B petitions are different. That shit has to be happening now. You can't say she was a really bad mom last year. But you can say she beat the hell out of Tiffany last year and we just found out about it. That's enough for an A. So there's a difference.
But I mean, for purposes of arguing that it isn't true, is there any argument that that evidence should go into?
Nope, not from a character perspective. So you can't try to prove that mom is not the kind of person who would beat little Sally. You need to prove that mom didn't beat little Sally on August 15th. There's a difference. What else? Yeah.
So we get an AB petition for Jane, and I just want to say my spouse from mom and dad. The department wants to bring in dad's threats about stuff from 10 years ago to do with a different one. That would be character evidence, and you should be objecting against the threats coming in with that.
Right. If they're right, but if they pled that, then it can come in. Like they're sort of in control of what the petition says. So you know, if you're reading the report, so if he never beat this current wife?
No, he did. He did beat this wife, but this is a different wife than the one he had 2 years ago.
Right.
So I would want to argue that the issues with the other wife from 10 years ago shouldn't come in.
That's not
character
relevant.
evidence.
Right. That's inadmissible character evidence.
Okay. But if they put it in, oh, and by the way, in the actual petition, by the way, he beat this old wife too, then that can.
It shouldn't come in. But what I'm saying is your judges screw this up constantly. So, right, they're tacking character evidence onto a specific occasion petition, which is not admissible. But your judge doesn't know that. So you guys need to educate your judge, and they love it when you do that. When you go, Judge, I just went through training, I found out you've been screwing this up for years. You know, exactly. You can give them my card. I used to do these trainings for judges when the AOC was around, but I haven't done it in a few years, so now they're done again. It's complicated, you know, and it takes a while for us to figure it out. And you know, judges are human. They don't. Most of them want it to be easy and fit into the little box and do it the way they've been doing it, but that shouldn't come in. I mean, that's propensity evidence.
But it shouldn't come in only if they don't put in the petition that incident happened to me.
Right.
If they do put it in, they do tack it on in the petition, then it is relevant because it's a part of the petition.
Right. So they could file a petition that just says Dad has beat the crap out of the last 3 women he's with. You know, and do dependency petitions now, I mean, I don't know if this is a county thing or a state thing, but our case numbers follow moms.
Right.
Yours do too. So they could say, look, we got these 3 other cases where he's beat all these women, and then this lady just had a baby with him. So we're going to file on that baby because they're living together. That's a character evidence petition. They could talk about those 3. All that stuff comes in. If he hasn't beat the shit out of her yet. Okay, but if he already did, you know, he got arrested for it. No, they shouldn't even be talking about the other ones. But they're going to put it in there. They're going to write about it. But you should object. Now, again, it's kind of, think about this from like an appellate standpoint. You want to pick your battles and fight about this on a case where it matters. So if he really has beat the crap out of the last 4 different women, and they're all open cases right now, you ain't winning that one, right? So maybe you pass. That's not the one you want to spend your time writing a motion. But you know, on the ones where they're slamming your client, and it's not proper, then I would object. All right, more bottom line. Character evidence is probably always admissible at dispo and review hearings. So all this time we're talking about jurisdiction, trying to sustain a petition. It probably always comes in at dispo and review hearings. So this is where the agency is going to say, how often does jurisdiction and disposition get bifurcated?
Yeah.
A lot?
If there's some condition placement.
Well, in that case, here's where I'm getting at. If you got different reports for jurisdiction and disposition, you can object a lot. For us in San Diego, generally we get the jurisdiction disposition report.
Yes.
So they're going to say, and they have a legit excuse when you object to this stuff, you're objecting to its use on jurisdiction. Because at dispo, when you're talking about placement, character evidence almost always comes in. Think about family law and custody cases, right? You're allowed to say, he's a gambler, you know? He's not as good of a choice as me. I go to church every day. Here's my church letter. In placement litigation, we're asking the court to perform a risk assessment or a prediction of future conduct. So character matters. Remember, this is character for parenting or propensity to commit physical abuse. Specific character traits, whatever your case is about. It's not general character. Okay? Stick to the topic. If it's a molest case, stick to propensity to molest. You know, if it's a neglect case, little Jimmy was found wandering around on the 10 freeway in the middle of the night by himself. You know, you're talking about character for parenting. Not talking about whether or not they take their vitamins every day. Keywords to look for are best interest, risk, and detriment. If you're litigating those things, character's probably coming in. Okay? The fight here is at jurisdiction. That's why on, do you guys ever get a Psych Eval pre-dispo?
No.
Yes.
It's not admissible pre-dispo.
Why? Who said that?
I did. And Alicia asked.
Okay. Why? But what's the theory?
Well, it's not admissible. I don't know what the theory is. I just know it can't be used.
So when let's move it up to a 6-month review, to 1 hearing. And your client had a Psych Eval as part of their case plan. Is the judge allowed to review that?
Yes.
In determining placement
Yes.
and return? Right.
Yes.
So when you're talking about the risk assessment and the best interest, character evidence is okay. But again, it has to be specific.
So can they use sometimes you have a non-offending client, and here comes dispo, and now you want the child released to you because you're non-offending, non-custodial. My judge will jump in the back and find the fact that you had for instance, in my case, it was a domestic violence that had occurred with that mother years ago, like 4 years back, and it was one that he went to criminal court, whatever it was, so he was convicted of that, okay? But they didn't have a case 4 years ago, so it's not like he failed to comply with anything for DV or anything like that. But his excuse to me when I asked for release was that my client had this domestic violence issue, and he was probably violent, and he said the child probably witnessed, DV, which that's total speculation. And he would not release to that dad because of his domestic violence conviction from 3 years ago.
Right. So.
Is that good?
No, I mean, I have a whole different training on shitty judges. I think your judge obviously is stretching, looking for a reason to not play.
Well, the guy lived in Honduras, so it wasn't all, it wasn't that easy either. But still, I don't feel that my client he didn't have any notice that he was even going to have the opportunity to have the child in the reports. They were asking him whether he wanted placement because he was the one that was, not offending. And so, yeah, we filed an appeal for that. It just, the other day, it just happened.
Yeah, I think that's a wrong call. But, on appeal, who knows?
Yeah.
But when it comes to this stuff, it's, this is about a jurisdiction fight. Feel free to put it in there when you're later in your case. It's always admissible when you're talking about placement and best interest. But that's about it. I'm about done. So we're like a full half hour early, unfortunately. So questions on either, on kid witnesses, anything pop up on the child witness? Yeah.
Just about character. If they're trying to use an old dependency case against the parent in character, but that parent was never present, never had an attorney, and it was found true by default, are you able to use any of that to try to get that the parent never received due process in the older case to avoid that character evidence?
Well, I mean, I think it is character evidence if they bring it up. I don't know enough to know whether it's proper or improper in that circumstance, but for jurisdiction, unless they're proving, unless it's one of these cases where, you know, it's happened a bunch, so we think it's going to happen again, it should be inadmissible. Now, so it sounds to me, though, like your question is more like if they open the door to it, and I think that's fair. So, look, if your judge screws this up and says, no, I'm going to let all this stuff come in, if they're opening the door, so they've opened the door to this prior unfounded referral, and your judge says, I'm going to consider that for jurisdiction. You know, I think this is a pattern. Then I think you're allowed to dive into each one of those, you know, and talk about whatever it was, you know. Okay, we're going to explain. You want to go down that road, the trial just got longer. You know, I'm going to need 8 days now, Judge. You know, but I think that's improper character evidence. Anyone else? So my final slide is thank you. Be proud of what you do every day. There's likely no other population in the state that needs a lawyer more than dependency parents. So be proud of what you do every day. See, you can get rich doing dependency. That one's a joke. Look, you can. One other thing I do, if you guys feel like picking my brain, I teach a lot of trial skills. Like I said, I think the next one we talked about doing is opening and closing. Many people do opening duty. We're going to fix that. That'll piss off your judges too. But if you want to find me, I'm on Facebook as Kevin Lemieux Attorney. I'm on Twitter, Instagram. I have YouTube with a bunch of training videos. My website is lawyerkevin.com. I also sue the agency sometimes in civil cases. So if you have 1983 kind of stuff, you can run it by me. I like suing the agency. It's kind of fun. They make it really hard though. But or the department. I also represent kids that were hurt in foster care. So taking money from the county. It's fun. So if are there any other questions on either topic? No? All right, thank you. You get less MCLE now because I finished early.
Okay, before everyone rushes up here, this is for 3 hours at the top. So all of you guys, please change it to 2.5. If you get audited, we will say you only were here for 2.5 hours, so please change it to 2.5. Cool?
Yeah.
All right, thank you.
Yes, Rachel.